Hello and welcome. I'm Erik Stegman, the CEO here at Native Americans in Philanthropy. And thank you for joining us for another of our sessions, member education sessions today. This month, we're focusing on an issue very near and dear to my heart, protecting the Indian Child Welfare Act. And I'm excited to be opening today's discussion with Dr. Sarah Kastelic, Executive Director of the National Indian Child Welfare Association. Welcome, Sarah.
Hi, Erik. Good morning. So happy to be with you and to have a chance to catch up with you after this momentous Supreme Court decision about the Indian Child Welfare Act.
Me too. Day that we got the Supreme Court decision, and we're going to be talking a lot about that recent fight to protect ICWA, but I think what a lot of people don't realize is it actually isn't a recent fight. It's a fight that our people have been going through for generations, but it actually goes a lot further back for you and me and our roles together. One of the reasons I care so deeply about ICWA, and a lot of people may not realize, is that you were actually one of my very first bosses when I first moved to town after law school, and I knew very little about child welfare issues in general, but especially the Indian Child Welfare Act. And I had the pleasure to work for you at the National Congress of American Indians at the Policy Research Center, where I think you had just gotten it off the ground not far before I got there. And what I learned from you about these issues was so personally moving and meaningful to me. I had been working a lot in the violence against women space, but this is something I realized is so connected to my own family, having a great grandfather who ran away from his boarding school and was really disconnected by his family because of one set of really terrible policies that our people have dealt with. But I just really appreciate what you gave to me in that early stage in my career, and I've really held that close to my heart over all those years. And thinking about the importance of these relationships and our work in our communities, I'd love to talk about the Protect ICWA Coalition. But first, I'd love to just hear some of your opening thoughts on sort of how you come to this work, and then we'll dig into some of the most recent work that we've been doing together.
Thanks, Erik. Well, it is a real joy to think back fondly on those memories of working together at the National Congress of American Indians, where we were starting the Policy Research Center, which was a new piece of infrastructure for Indian country, really thinking carefully about the data and information that tribal leaders need to make educated decisions about the well-being of their citizens. And think something that I learned from you, something that was so striking to me about the opportunity to work with you at that point in my career was that, I had just finished school, so I had a strong research background and was very focused on that, and really wanting to get a lot of important information and data into the hands of tribal leaders. And I think a gift and talent that you brought to our work was really to help us think intentionally about how to make it digestible, how to make it attractive to people, how to share information in a compelling way that would draw people into the work that we were trying to do. And so I think that's a gift that I've seen you use throughout your career in different ways. And kind of as a new PhD, I was really just focused on the information and data, and you really helped me to think about how do we make this palatable for people? How do we make it attractive? How do we invite people in to learn more about something? And I think that's a lesson I learned from you, and something that is still so important in the work that we're doing, especially in the small but around the Protect ICWA campaign.
Well, I really appreciate that, and I think it says a lot about why we've been such a good team over the years in our different roles here. And it's been a real honor to be able to work with you around this most immediate effort, which has been the Protect ICWA Coalition. And we're going to get into some of the meat of what's actually behind the decision and some other things. But I wanted to talk to you a little bit about some of the behind the scenes. I think a lot of times when you look at some of these fights that we are brought into to defend things like the Indian Child Welfare Act, it can seem like a rapid response, a very quick response. But can you share some of the behind the scenes from your perspective about how this coalition's effort really came together, how you built on your own relationships, and how the other organizations contributed to really get us to this important milestone in defending this law?
Yeah, great question. So the Protect ICWA campaign is a partnership of 4 national Native organizations. My organization, the National Indian Child Welfare Association, and our partners, the Native American Rights Fund, the National Congress of American Indians, and the Association on American Indian Affairs. So all 4 of these organizations have a history in working in Indian child welfare. And for many years, we've been working together. The Protect ICWA campaign came about in the wake of this case, Haaland v. Brackeen, that we're going to talk more about soon. But this was a constitutional challenge to the Indian Child Welfare Act, a 45-year-old federal law that was brought in federal district court in the Northern District of Texas. And so our 4 organizations came together quickly, working in this way since 2017, and even episodically, I would say, long before that, when we look back to the adoptive couple v. baby girl case that happened in the early 2000s. The decision was handed down in 2013, about a decade ago. And so we had a history of working together on these matters. And I would just say also that, tribal leaders were very helpful to us in saying, we hear from you different organizations, you come to our meetings, you give us updates about these things. And it's really helpful for us, for you guys to all be on the same page. So I think that was really helpful to us in getting more intentional about our collaboration, coming together on a regular basis, really focused on what we think of as like the 3 legs of the stool of our work together. So on the one hand, being very attentive to and focused on litigation, and what we saw as a wave of litigation that came about, especially after some policy changes at the end of the Obama administration that really strengthened ICWA. We saw a really strong reaction, some backlash from opponents of ICWA. So we're very focused on litigation. And at the same time, really focused on policy work. So how do we strengthen ICWA implementation and compliance? At the state level, are there things at the federal level that can happen? What can tribes be doing themselves? So really looking at all those levels of policy making. And then also the third leg of the stool, something that's newer to our coalition is a really strong focus on communications. So that was a hard lesson learned from the prior experience with the other Supreme Court case I mentioned, Adopted Couple v. Baby Girl. And in that case, we saw that Indian country really didn't have a voice in the media coverage around that our narrative was really drowned out, that there weren't Native spokespeople. Really what we saw is ICWA opponents who dominated the media coverage. And so this time around, as we started working fairly early on in this case, the need for better communication infrastructure and for a stronger skill set around engaging in digital media, thinking about earned media, identifying spokespeople, those were all things that we knew we needed. And actually, my relationship with you, Erik, was the way that we came to be able to focus on this more. So you introduced us to Rally, an advocacy agency, in the early days before we were raising money for this actively. You helped to support some in-kind gifts, some time from Rally to work with us and our coalition. So again, those relationships are a really important common theme along this topic, and the way that we work together in solidarity to generate the amazing outcomes that we'll talk about more later.
Yeah, I think, so many good points that I've just I've seen over the years in working with you on a lot of these issues, whether it was some of our previous successes in strengthening some of the work in existing federal laws to support our children and families, all the way up to this most recent defense. But, I think the role of tribal leaders, I think, is often misunderstood by a lot of the outside public and just how critical they've been in this. And I've just seen so many individual tribal leaders doing such incredible work to advocate and to push on these issues. And I'm glad you pointed to the communications piece, because I think one of the things I was so excited to see was this united voice, and really so many different voices from our communities lifted up, whether those were the families directly impacted, our tribal leaders, our court staff. We heard from all the people who really understand this at the front lines. And so, work this big takes so much different support, and especially having to bring a coalition together and to really keep everyone in a unified direction forward. But that takes resources, and I know NICWA has wonderful relationships with several different funders, and obviously our role here is to be a platform for all our communities for philanthropy. And so, for those who aren't familiar, what does that support look like for your work, and how important are those relationships? Because I know you keep coming back to relationships, and that's one of our central values as Native people and at Native Americans in Philanthropy.
Well, I can give you two really concrete examples. One is a relationship that we have with a longtime funder for more than 30 years. So Meyer Memorial Trust is a local foundation here in Oregon that's funding work in Oregon and in Southwest Washington. And we have a relationship with the CEO. We have a really terrific program officer who advocates internally for support for our work. And as this fight for ICWA was ramping up, as the opposition, very well resourced, very well organized, was making their case, we reached out to the long-term partners, to the friends that we've had for many years. And we've gone to Meyer Memorial Trust at really key points in our organization's history, where we were really seeking support for making key organizational changes, for significant investments. So it was a natural fit to talk to Meyer about this fight for ICWA, and their support happened in a number of ways. So one thing that happened right away was a transition from project support to general operating support. So much more flexibility and discretion, and fewer administrative burdens in terms of the reporting. So that was a really wonderful gift. But something I appreciated is that relationship went so much further than money. So the trust invited us to speak with their board of trustees and with their staff. So we had a lunch and learn session where we talked about what is the Indian Child Welfare Act, why is it important, why are tribes fighting to defend it, what's at stake in the Supreme Court case. So they did a lot of internal education there, and then also actually joined forces with our communications work. So then we had a separate meeting with their communications team to talk about what role could they play to amplify some of our messaging, to identify other spokespeople locally, to try to influence the local media to get some stories placed. So what a fantastic relationship that they're able to support us financially, but also in so many other ways. And then a very different example that I would give, again, really focused on relationship, is as I was starting to try to figure out a fundraising strategy, I had a conversation with friends over at First Nations Development Institute, their CEO, Mike Roberts. And I was just saying, tribes are funding this work, and we need to get philanthropy more involved. So what are your ideas? What prospects do you have for me? So they introduced me to a couple of people, and one relationship in particular, a foundation who chooses to remain anonymous, but gave us an initial 1 year, $100,000 a year general operating support grant. And then just recently renewed their work with us with a 3-year, $300,000 grant. So the opportunity to engage with them, to talk with their staff on a regular basis, and for them to decide that even in the wake of a great decision, that they wanted all in on the important advocacy and policy change that needs to happen now. So really different relationships, and there were really key people who helped us facilitate those relationships and engender the support that we have for ICWA right now.
It's just such a beautiful story on so many levels. And this is the kind of work we're always trying to lift up and promote. And sometimes it comes out of some pretty hard moments, like what we've gone through and what you and the coalition have been leading. I think one of the things that really rings through to me is just that we're always trying to explain to external audiences outside of Indian country why relationships are such a central part of our work. And on one level, I think oftentimes philanthropy doesn't actually realize that a lot of our best people in philanthropy really value relationships too, but I don't think they see how central that connection is all the time between our relationships in our community and our relationships with our supporters, our outside allies. And what I love about that is that you had a funder who's been with you for the long run, but had really stepped up in so many different ways, really helped leverage their own platforms in addition to funding. And then one of our longtime partners, First Nations Development Institute and Mike Roberts, who have been there in Indian country for a long time doing this work, but being a partner and a relative from the inside who was able to do that work. And so, I think that's exactly what we hope to sustain in this work. And so, the thing I wanted to talk about next is just that the Supreme Court decision last month that reaffirmed ICWA, which we're going to be going into next. We got some amazing panelists who are going to break this down for our viewers. Brought in a lot of different elements, but one of the things I'd love to hear from you while we have some time together is what's next. So when we're talking about that this is always long-term work, one of the things I told everyone when this decision came down, when they were asking me, what it means, there were so many things, but one of the things was, for once, we finally don't have to just constantly be defending this federal law that our ancestors fought so hard to get in place in the first place. And so now as we move forward, there's still so much work to do, but what is the role of these relationships that you talked about and that work moving forward? And can you share some of your thoughts on how we build upon those relationships, carry this momentum forward, and build stronger lasting relationships with philanthropy too, to really invest in the future alongside some of this defense that we've constantly had to do?
Well, first of all, you're right. It's a huge relief to not be in the position of trying to claw back some of the protections that an adverse ruling took away. So we're not in that position, thank goodness. We were prepared for that. We were preparing for 5 different scenarios about what a decision in this case could look like. But thank goodness we got the best decision that we really could have. So in thinking about what's next, those relationships, again, are so important. At the Supreme Court stage of this case, there were 21 amicus briefs that were filed by an amazing array of supporters, people who could speak to the importance of ICWA from very different perspectives. So former foster youth, from tribes themselves, from child welfare experts, from Indian law experts. So states themselves, state governments, members of Congress. So people who have very different perspectives on the law and what it does and why it's important. But we're able to come together through terrific work that our partner, the Native American Rights Fund, undertook. So they orchestrated an incredible amicus brief strategy where we had all these wonderful briefs filed in support of ICWA, hundreds and hundreds of tribes and organizations and individuals signing on to briefs. So really, just an overwhelming expression of support for the law. And when you look at the ICWA opponents, they have a few briefs. And then when you look at the tribal side in support of ICWA, it's like overwhelming support. And so we knew that with this great decision that we need to take full advantage of the solidarity, of the partnerships, of the momentum for the Indian Child Welfare Act, the support for the law, and translate that into the next phase of advocacy. So bringing those relationships, bringing those partnerships, bringing our strong bench of support that we've built from non-Native allies, in particular through some of our digital work in the Protect ICWA campaign. So I really feel like we have a very educated group of supporters who are ready for the next phase of work. In our view, what I keep saying at NICWA is we need to press the gas pedal all the way to the floor. Like, we got a great decision and we can't let up. So on the one hand, we still have to be vigilant about further attacks. Our opponents have made it clear. Their mission is to take down ICWA, and they're going to keep trying to do that. They're going to keep bringing cases. And so being very vigilant in monitoring litigation and paying attention to child custody cases and the attorneys who are showing up for those cases, and really monitoring what's happening, because the opposition is going to keep looking for cases to bring. So that's one piece of the work to pay attention to. But on the other hand, the really exciting, forward-looking, proactive work that you were just alluding to happens on multiple levels. There are fantastic things that tribes are doing, and we'll talk more about that in the next segment, I know. But lifting up tribal best practices and continuing to build tribal capacity, because the best defense is a good offense, and the stronger our tribal systems are, the more kids we can keep out of the state system. And so that's a really important area of work. Strengthening tribal state relationships, again, that theme about relationship. But in so many ways, the relationship between states and tribes is determinative of the kinds of services and supports families actually have access to. So that's critical. And then we also know, as this decision affirmed clearly, that the federal government has a very important role in child welfare. They're not just a passive funder of child welfare services, but they have a really important role in setting standards in child welfare. So how can we call on our federal partners to step into this role more fully? How can we help them to think about a role in data collection so that we have better information about what's happening with implementation of this important law? The Indian Child Welfare Act is the only federal child welfare law that doesn't have a regular review. Every other piece of child welfare legislation comes up for periodic review. There's data collection associated with it. We're monitoring how is this happening, how is this law being implemented, what else needs to happen to strengthen it. But that doesn't hold for ICWA. So how can we work with our federal partners to think about some of these key elements that will help to improve outcomes for kids and families and help us better monitor how that's working? So I think there's a whole lot of work ahead of us. And again, we're really relying on those key partnerships.
Well, consider NAPA a partner in putting that pedal to the floor on all of this, because I just think I'm still walking away with so much energy from this, and I know that there's a lot that we can do to build a stronger agenda around Indigenous children, youth, and families. And I think we have so much to bring to other communities in the U.S. One of the things I always shared with people in the defense of this was that ICWA was really seen as a North Star. It was something that strove for a better rebalanced system of how we protect our children and our families and our communities. And I know these systems are such a struggle for so many other communities. And now I think we can really take a lot of what you just said and focus on how our own leadership can really keep changing these systems and improving them. So I'm really looking forward to continuing to be a partner. I know my whole team is, and I just so appreciate you taking the time today to be here with us, Sarah. And we've got a really great panel coming up next to kind of dive into some of the details. You're going to see some of the amazing other organizations who are part of the coalition. But thank you for joining me, Sarah. And I'm really looking forward to the next piece, which I'm going to kick over to my colleague, Brittany Schulman, who's our Senior VP of Programs. Brittany, over to you.
Thank you so much, Erik. And thank you for joining this conversation around the historic reaffirmation of ICWA and what's next and how philanthropy can continue to support this vital work. We have an amazing panel of folks who are going to really share about how this has affected them and how that they are continuing to lean into that support. So as I bring you in, as you come and join the conversation, please tell us a little bit about who you are and your background. So first, I'd like to introduce Erin Dougherty Lynch, who is a managing and staff attorney with the Native Americans Rights Fund. Hello, Erin.
Of course, I have myself on mute. Apologies for that. Hello, good morning.
Can you tell us a little bit about your background?
Yes, thank you so much. I am Erin Dougherty Lynch. I'm a senior staff attorney at the Native American Rights Fund, and I am also the managing attorney of NARF's Anchorage, Alaska office. And NARF has been involved in Indian Child Welfare Act issues for many decades, and there was a lot of work done that predates me joining NARF about 13 years ago. But NARF in recent years, in my involvement in the space, has been in the Protect ICWA campaign that Sarah was just discussing, and in the 3 successive federal court challenges to the Indian Child Welfare Act that have been brought over the course of the last decade.
Thank you so much, Erin. I'd also like to bring to the space Aurene Martin, who is president of Spirit Rock Consulting. Welcome, Aurene.
Thank you. Good morning. Thanks for having me today. My name's Aurene Martin. I'm a member of the Bad River Band of Lake Superior, Chippewa. I'm an attorney and an advocate here in Washington, D.C. I specialize in Indian law and policy, and I work with Indian tribes across the country to help affect decisions that positively affect Indian country here in Washington. And most importantly, I'm a mother of 2 beautiful young men who I adopted through the ICWA programs at their tribes.
Thank you so much, Aurene. I'd now like to bring in Dr. Joannie Suina, who is the National Native American Boarding School Coalition as the Development Officer. Welcome, Dr. Joannie.
Good morning. I'm Joannie Suina, and I'm coming to you today from Tiwa Territory. I serve as the Development Officer at the National Native American Boarding School Healing Coalition. A little bit more about me. I'm also a mother. I have 4 children, and I formerly served on the board for NABS from 2018 to most recently in June, taking my new position at the coalition. Thank you for having me today.
Thank you so much. And last but not least, welcome back, Sarah.
Chimai, thank you so much, Brittany. Good morning again, everyone. I'm Sarah Kastelic. I'm a citizen of the native village of Uzinki, which is a small Alaska Native village near Kodiak, Alaska. I'm a social worker by training, and I have the honor of serving as the executive director of the National Indian Child Welfare Association, 40-year-old nonprofit, which is headquartered in Portland, Oregon. So really pleased to be with all of you here today.
Thank you again. Amazing panel, and we're just going to jump right into it. We already heard from Erik and Sarah about the importance of relationships, both within our communities and in the work to continue protecting ICWA. But for those outside of our home communities who may not realize that ICWA is about more than adoption, we'd like to back up a moment and discuss what the Indian Child Welfare Act is, just how important it is, and why it's even needed. So Dr. Joannie, the work that's being done by the Native American Boarding School Healing Coalition is directly related to this. Would you share with us some of the history of where ICWA came from, why it is needed, and what it hoped to address?
Yeah, thanks again so much. So ICWA was passed in 1978, and it was passed to address and protect the unnecessary and egregious removal of Indian children from their families. And as we look at the history, the tumultuous history of federal Indian law and policy across our communities, we've seen these various policy eras where we're being forcibly removed, we're being assimilated, and our children are being forcibly taken, stolen from our families and communities, and really ultimately with the goal of not only assimilating them, but breaking down the full nucleus of Native families. We're talking about community, culture, language, practices, traditional calendars, and in understanding what those ripple effects look like in our communities today, we can see that translated through the ways in which substance abuse, the ways in which parenting, family, community makeup has shifted itself away from these values and ways of knowing. And I think it's also important to point out that the law itself is designed to address that reality, that there has been this history of forcibly removing children, and also to create certain protections to put in place to prevent that from happening, and also to look at the stability and the security of Indian tribes. And what we have continued to be in dialogue about throughout the time of Brackeen v. Haaland is that we know that ICWA, in terms of the question being, did it discriminate on the basis of race? No, we're sovereign nations who have the power to determine our membership and how we define our community tribal citizens, and what that means in terms of this being an inherent birthright. Sovereignty is not something that was just given to us by the federal government. This is something that is inherent to our communities. It's a birthright. And we've been fighting this narrative since the establishment of boarding schools, since Carlisle Indian Industrial School, when our children were taken from all across Turtle Island and placed in institutions. And today we know that there are 367 boarding school locations operated by 14 different religious denominations, various state and federal agencies. And when we think about that intentional breaking apart of Native families and the continued work that needs to happen in terms of healing, we can't just think about it from a trauma-informed perspective and say that our social workers and folks that are on the ground level carrying out this work to protect Native children and families, we also have to look at it from a healing informed perspective that is inclusive of this history, because this was an act of genocide and it is continuously ongoing. And I think that in terms of this political, designation that we have as Indigenous people, as tribal citizens, again, this is something that we're continuing to press our heels deeper into the sand and understand where some of those implications lie in terms of where are these records? What are some of the known locations of how and where our children have gone to and where they've gone missing at these known locations as well. And ultimately, I think to wrap up this question, we're doing this evaluation of, we've seen this before. We've seen our children taken away from us before. And so being able to address this from a historical side, because this work is also absolutely about protecting our most sacred, our children, but it's also not in a linear fashion. It includes the past as well. And it's important to integrate this understanding of what the boarding school era did.
Thank you so much, Dr. Joannie. And I just want to open it up to any other of our panelists who want to talk a little bit more about, why ICWA was needed, what it hoped to address. I think that was a really good connection between that particular legislation and then where the work you're currently doing is.
I can jump in, Brittany. So at the National Indian Child Welfare Association, we do a lot of trainings on ICWA, and we talk a lot about that history of assimilationist policy that Dr. Joannie was just sharing with us. And I think, we try to boil it down pretty succinctly. One of the things that we say is that the recipe for colonization is the same the world over. And if you look country by country, if you look at Indigenous community, Indigenous group by Indigenous group, we had very similar experiences, right? So there's an actual recipe for this. So there's intentionality behind this, and there's a sequencing of this, right? And so if we think about what the ingredients for this recipe are, first, the colonizers took the land. Second, they controlled the natural resources, especially water. Third, they usurp Indigenous governance. They supplant it with other forms of Western governance. Fourth, delegitimize Indigenous thought. So Indigenous worldviews, Indigenous values are really devalued. And then finally, the fifth ingredient and the most important ingredient is to take the children. And that's so critical because that's the step that severs connection, right? That prevents children from knowing who they are, from having a strong sense of identity. It severs their sense of belonging to their extended family, to their community, to their culture. And so that history that Dr. Joannie was just describing is really fundamentally this very intentional history with a number of different steps for colonization, but ultimately about that forced separation of children from their families to make sure that children don't know who they are, to make sure that they don't have that connection, that they're more easily assimilated into mainstream culture. And fortunately, what these hundreds of years of experience have shown is that Native people and Native communities are incredibly resilient. And so despite these efforts, we're still here. And we know how to care for our children. My community, we can trace our people back 9,000 years in that part of our state. And guess what? For 9,000 years, we've known how to raise healthy, thriving children. And many of those practices are still passed down today. So we know what's best for our kids. It's the reason why ICWA is so important. It's the reason we recognize that tribal nations play a critical role in ensuring the well-being of their citizens, especially their most vulnerable citizens, children who come into contact with the child welfare system.
Thank you so much. And I just want to say, thinking about the history of ICWA as a tool of colonization is, we know that is still affecting our people today. We understand that everyday effects of abuse and neglect are continuing to affect our families and communities. But we also know that when our child who has those experiences has access to community-based, culturally appropriate services and care, they are so much more likely to grow up and live safe and healthy lives. Aurene, not only you're an attorney who specializes in ICWA cases, but as you mentioned at the top, you're a parent of two wonderful children that you adopted through the process. Would you mind sharing with us some of your own experiences and the ways ICWA has impacted your own life?
Sure, and thank you for the question. I think a lot of times when we're talking about ICWA and talking about the need to preserve ICWA, we talk about it in the abstract and kind of in the big picture way. But one of the things that we don't always talk about is how it affects so many people in our communities in a personal way, and not just once or twice in a lifetime, but it can affect your whole lifetime. And for me, I've been fortunate to have been connected with, for whatever reason, ICWA since I was a kid. I grew up, and I have a very large family. I think many of us do. And my grandmother fostered children who were placed out of home. And so I had a lot of connection to these foster kids. They became part of our family. We talk about relationships. We established those relationships, but they were part of our community and they were able to stay in the community. So once they went back to their parents, they still were part of our family and part of the larger community. And I think that's a really important thing to remember. But once I went to school, I went to college, I went to law school. When I first started practicing as an attorney, my responsibility was to handle Indian Child Welfare Act cases for the tribe I worked for, the Oneida Nation of Wisconsin. And that brought a really unique perspective to me on what Indian child welfare was, what the Indian Child Welfare Act was, because for that tribe, the Oneida in Wisconsin, it's a public law 280 state. And one of the aspects of public law 280 is that civil jurisdiction is with the state. And so when kids were removed from their homes, wherever it was, they were in state court. And so what it required was the tribe to become involved in these cases wherever they were within the state of Wisconsin, but also out of state. And it takes a tremendous amount of money, time, and energy to be able to track all those things. And so again, when you're talking about the colonizers, it just split everything off, and it causes you to spend so much more time and energy to keep track of it. But one of the things that became very clear to me in doing that is in some counties where there are a lot of cases, the state court was very good. they were educated, they knew what the process was, they worked with the tribe, but in a lot of places they didn't. And it wasn't because there were nefarious purposes or ill intent. They just didn't know. There's a lot of education that's needed. And so I would go all over the country and work on these cases. And sometimes I had to tell the court what the law was so that they could follow it. And other times it was just easy. But also the other thing I mentioned before was that it takes a lot of time and energy to track these cases. And I'm still awed and impressed at how much tribes are able to do to be able to keep track of these things, because they have social workers that have to keep track of all of these cases, to work with all of these families wherever they are. And they internally have to make decisions on what the best placement might be for a child, and what's in their best interest. And they do that, and they do a very good job of it. So really, that's one thing I just always wanted to remember. But while I was working at Oneida, there was actually a period in the 1990s when there were attempted changes to ICWA. And I worked on federal advocacy for the tribe to try to protect it. And it became also very clear then that, federal law and policy really affects tribes at a very basic level. And so I moved to Washington, D.C., started a family. Well, wanted to start a family. I got married, and then I became, my husband and I couldn't have children. And so that's when it was a very natural decision, but we thought, well, we'll try to adopt. And I was fortunate that through the Oneida tribe of Wisconsin, through my mother's tribe, the Menominee tribe, I was able to adopt two baby boys. And, I'm raising them here in Washington, D.C. They're 14 and 15. And I think coming back to the question, how does that really help children? How does that make them healthier and happier? They're not raised on the reservation, but they're here in Washington, D.C., but we have the opportunity. I think we're lucky that we go back and forth. We go back and forth frequently. They have family relationships. They have the ability to be part of the community. They have the opportunities to see their cousins and be part of the community at large, participate in ceremonies. And so I think just knowing that makes it so much easier for them to accept that they're a part of the community, that is available to them. And I think that makes for a healthier, happier child. But it goes back to relationships, right? They have that relationship with their family. They have that relationship with their cousins, with the community, with the people that they know, that I grew up with. And I think that's really what it's all about. I've kind of come full circle here, though, because I started my career in Washington. I came out here because of the Indian Child Welfare Act, and here we are back where I kind of started, and we're still advocating for the Indian Child Welfare Act. We're still trying to protect it. We've had this tremendous victory, but at the same time, we know that we still have a little bit of a fight ahead of us. But now I know, having seen all the parts of this process and having my own children now, it's worth fighting for just every part of it. The sovereignty part of it, which is the big picture part. But for these two boys that I brought home when they were babies, and I'm raising into young men who are proud of their background, part of their culture, and proud to be part of our family.
Thank you so much. It's so important. That's such a reality that we're all living in, living that back and forth, having the urban Indian experience while also being really connected to your community that may be really close or may be really far. So it's such a privilege and a pleasure that you get to have that responsibility. Parenting, I often say, it's a privilege and a pleasure. And thank you so much for sharing your story. Now, we've touched a little bit on some of the issues that ICWA addresses. And as the panel knows, ICWA is not just about child welfare. It's not just about protecting our kids, though it totally is about protecting our kids. Why is protecting so important, the Indian Child Welfare Act, so important? And the threats in the Brackeen case, why were they so serious? And Erin, I'm going to come to you because I know this is a totally loaded question, and you can help us understand what this case was about and what the Supreme Court decision actually means and how it goes beyond in child welfare.
Yeah, sure. Thank you so much again for having me. So you're absolutely right. I mean, even though this case was about the Indian Child Welfare Act, at its core, it really wasn't in terms of the arguments that the ICWA's opponents were bringing. The plaintiffs in this case, really the lawyers who have represented them and their amici supporters, argued throughout the life of the case that they were the real entities that had the best interests of Indian children at heart. However, I think it's important just to sort of, as we conceptualize the case, understand that these law firms and interest groups are not in any other way involved in the child welfare space at all. Their involvement in these conversations has been solely in the context of trying to tear down the Indian Child Welfare Act. And as Sarah mentioned at the beginning, all of the nation's leading child welfare, adoption, foster care organizations filed briefs in support of ICWA at almost every stage of this case, and especially in the last stage, the merit stage before the United States Supreme Court. So there is an overwhelming, I think, understanding by the experts in the area that ICWA is the gold standard in child welfare law in general. When you look, so if you understand sort of the context of the attorneys and the organizations who have been opposing ICWA and the other cases they're involved in, and their specific arguments, which I'll talk about here in a minute, it sort of teases out exactly what you said in terms of this case was not really about ICWA or about child welfare. Broadly, this case was really about an attempt to restructure the relationship between the federal government and tribes, and then also restructure the power dynamic between Congress and the states. So the entities that were involved in this case in opposing ICWA, again, the attorneys and the interest groups that were involved, their goal, even though they've never been extremely explicit about it, but based on their other cases that they're bringing and their other actions, they are focused on gaining access to tribal natural resources and tribal revenue streams for themselves. And even more broadly than that, they would like to restrict Congress's power. So I'm just going to very briefly work through some of the main arguments in the case, and I won't go into too much detail, but happy to follow up either in questions or after the fact as well, if people want to dig into the details. So the first main argument that kind of shows what this case was really about was arguments geared towards Congress's authority to enact legislation that relates to tribes and Indian people. So this was an argument that really centered on what the Indian Commerce Clause means. The Indian Commerce Clause is a specific clause in the United States Constitution that relates just to tribes. There's some really interesting briefing from some historians and some law professors, if you want to dig into this in the amicus briefs, that talks about the Articles of Confederation and sort of what a mess it was when states were having direct relationships and negotiation with tribes. And so when the United States and the drafters of the United States Constitution sat down to write, they basically restricted the right to deal with sovereigns, with tribal sovereigns, to Congress, to the federal government. That's known as the Indian Commerce Clause. At the time, the conception of commerce, what commerce meant, was very broad. And the arguments in this case, some of the arguments, I should say, were that the court should sort of reevaluate that meaning of commerce and restrict it basically to only instances where there was sort of a actual money at play, right? The effects of that would be that ICWA is not, Indian child welfare is not commerce, and so Congress had no authority to pass it. It would also, as some of the justices noted at oral argument, put much of the entire body of federal Indian law into question. For example, any of the congressional statutes that relate to Indian healthcare, or any number of other statutes that tribes rely on every day, or make use of every day, I should say. All of those, that body of federal Indian law is found really in Title 25 of the U.S. Code. And this argument would have undercut a substantial amount of Title 25. It would have put a lot of federal legislation, sort of made it vulnerable to challenges. The second argument to mention, which is very similar in its broad scope, is this argument that ICWA is race-based. And this was a very, I think this argument, like the last one I mentioned, caused a lot of heartburn by the folks involved in the case. But the idea there is that the plaintiffs were arguing that ICWA is a law because it relates to Indian children that is race-based and thus is subject to strict scrutiny and an equal protection violation. Now, we know that ICWA is not race-based. Tribes and the federal government were right on the law about all of these issues. But just to dig into ICWA a bit more specifically, a child is eligible for the protections of ICWA if they are a member of a federally recognized tribe or eligible for membership. There's nothing in the law that discusses race. There's nothing in the law that discusses blood quantum. It is all about membership in a tribe, or eligibility for membership, citizenship, really. So it's based in the political relationship between a child and their tribe, and the tribe and the federal government. And the plaintiffs in this case were trying to recharacterize what we call that political relationship as one that was racial in nature. Again, the effects of that would have been far-reaching, because if ICWA, which is by its actual text only applies to citizens or children who are eligible for citizenship in a federally recognized tribe, if that was considered race-based, then it's hard to see what in Title 25 would not also be considered race-based and thus vulnerable to another constitutional challenge. The last thing I'll mention, the last constitutional doctrine that I'll mention is this concept of commandeering, anti-commandeering. That is a relatively new constitutional doctrine identified by the Supreme Court just a couple decades ago. And the idea behind that doctrine is that there are certain topics, certain types of issues that are off limits to Congress, that those have traditionally been left to the states and are in the purview of the states, and that it's not proper for Congress to, quote, commandeer states on certain issues. So the state of Texas, which was one of the plaintiffs in this case, was the main party to advance this argument. And this argument was dangerous because it really threatened to undercut not just ICWA, excuse me, but any federal law related to child welfare, really, or to children. One example is the Civil Service Members Relief Act, I believe that's the name of it, which is a law that prevents, a federal law that prevents states from terminating the rights, parental rights of folks who are deployed and who are in military service and who are not there to participate in court hearings because they are serving the United States, in the armed services. So they were going after ICWA, but it would have opened, a successful commandeering challenge would have had a great effect on Congress's ability to legislate for children. And then you can extrapolate even out from there to other laws that might be affected. That also came up at oral argument, where you had one of the justices reading off a variety of federal statutes to Texas's attorney and saying, is this commandeering? Is this commandeering? And the Texas attorney said yes to every one of them. So just right there, it was 6 or 7 federal statutes that would have been just out the window. Those are the sort of the main 3 arguments. They all have sub pieces, and you can work out from there. As Sarah and others have mentioned, it was an enormous victory. The opinion came out on June 15th. The decision was 7-2, with Justice Barrett writing the majority opinion, and a very compelling concurring opinion from Justice Gorsuch. which I think many of us have been encouraging folks who are interested in learning more about the relationship between the federal government and tribes and the manner in which the federal government has been involved in the lives of Native children, often to the great detriment of Native children. It is really worth reading Justice Gorsuch's concurrence because he very clearly lays out that history. The court reached a decision on the merits of almost all of those issues, which means that that commandeering and sort of the Indian Commerce Clause and those issues are done, right? The Supreme Court has rejected those arguments from the plaintiffs, and that is that. On the equal protection argument, the court found that the plaintiffs did not have standing to raise those claims in this case. And standing is a sort of foundational legal concept in all cases. You have to basically be able to say that you are harmed by a certain decision and that the person that you are suing has the ability to remedy that harm. The United States Department of Justice, which was charged with defending ICWA, as they are charged with defending all federal statutes, and the tribes in the case had been arguing to all of the courts along the way in this case that the plaintiffs had serious standing problems. However, the district court, federal district court, and the Fifth Circuit sort of didn't really address those concerns or in a very substantive way. I mention this all to say that I know that the equal protection piece of it still hanging out there causes some anxiety, but I wanted to say that that the Department of Justice and tribes had been arguing in the case that there were standing problems. So it actually, I think of that this piece of the decision as a win, because the court is right, they did not have standing to bring those claims. What that means, though, is that we might end up seeing, might very well likely see soon, challenges brought in state court on equal protection grounds. As Sarah mentioned, the opponents are very well financed. They're very motivated. I would not put it past them at all. And in fact, I fully expect it, in terms of them bringing those claims. To me, it doesn't give me as much heartburn, I will say, because I personally am not sure that they have the votes on the court to entertain those claims. And because, as Sarah mentioned, there has been such an upswell of support for ICWA, and the suite of amicus briefs that came out of this last round of briefing are so excellent. And I think there's a lot there for attorneys and parties and advocates to draw on in continuing to push back on these challenges. Very briefly, I'll just give a bit of information on what is next to keep sort of contextualizing this case as part of a broader effort. So the same attorneys that were involved in Brackeen are pushing the same arguments in other cases with the overall goal of undermining tribal sovereignty and that federal tribal relationship. Matt McGill is an attorney at Gibson Dunn, and he was the Brackeen's attorney in Brackeen. He is involved, along with his colleagues, in a case in the federal courts in Washington State, where they are challenging the Indian Gaming Regulatory Act, IGRA, under the same types of arguments, these equal protection arguments. And that, Washington State federal courts are in the Ninth Circuit. That case is sort of lingering there now, but they are, I mention that to say that they are bringing these parallel cases. Again, that case has nothing to do with child welfare, but the same arguments, and it would have the same effect of really undermining Congress and Title 25. Last thing to mention too is that I think it's an attack on tribes, but and an attack on the relationship between tribes and the federal government. They also are continuing their attacks or efforts to rewrite the law as it relates to Congress and the federal government and those federal powers in general. So Paul Clement, who was one of the attorneys in the baby girl case that Sarah mentioned at the beginning, who has also fought tribes in other cases since Baby Girl, is involved in a case that's going to be heard by the court next term called Loper Bright, which is, you might think, a bit of an obscure case about federal fisheries management, but the goal, or his goal in his briefs, is to get the court to get rid of what's called Chevron deference. And Chevron deference is a legal test for determining whether to grant deference to a federal agency's interpretation of a statute. And the same entities that you saw in Brackeen, so the Goldwater Institute, Cato, a number of other organizations who were sort of attacking the federal tribal relationship in Brackeen, are involved in this case and are in this Loper Bright case, and are trying to greatly basically restrict the federal government's power to do much, honestly. So this is part of a broader effort to really, I think, restrict Congress, restrict federal agencies, and attack and undermine tribes. So I don't want to actually, I hesitate to end there in a way, because I don't want to end on a sour note at all. I think this case was just an enormous effort from just a tremendous number of people nationwide, and led by tribes, and Indian country should be enormously proud. I know a lot of this case caused a lot of anxiety for a lot of people. And yes, I have no doubt there are challenges to come, but I hope that everyone feels just a tremendous, not just sense of relief, but sense of pride in the collective effort that was put in to protect ICWA. And I think, I want to say in my heart of hearts, I think that this case could potentially, at least as it relates to ICWA, backfire on the folks who have been challenging ICWA for years now, because of the immense amount of support that showed up at that last stage in front of the Supreme Court, and the enormous, not just number of people who are involved in child welfare or who are in Indian country, but allies beyond and broader than that. I think ICWA is on, the strongest footing it's been in a long time, and that we should all seize this opportunity to push for better and more consistent implementation nationwide. So I'll stop there.
Thank you so much, Erin. Especially drawing that through line between this case and all the other attacks on tribal sovereignty, and just wanting to put a pin on tribes or governments. And that's something that we do not learn often. I do want to open it up to the other panelists if others would like to add in a little bit about how this goes beyond child welfare, and what this decision actually means. And if not, we'll go right into our next question. For those who don't work in ICWA spaces, they may not realize that the daily implementation is not controlled at the federal level. And because of this, there's a lot of work that needs to happen, continued work, to make sure that ICWA is as successful as it can be. And then Sarah, would you kindly elaborate on how ICWA directs states, and what kind of understanding and action is needed at the state and local level to strengthen this work?
Great. Thank you, Brittany. The Indian Child Welfare Act is a law that governs state behavior. It makes requirements of states to meet certain conditions before they can remove Native children from their homes. So we can think of this as like putting up guardrails because of that history of behavior that we were describing, that forcible removal of kids from their families. And so ICWA attempted to stop that by putting these new minimum standards in place for states to be able to remove Native children. So what I would say is that ICWA has been around 45 years now. And in some ways, it's been a great natural experiment. So in states throughout the country, states and tribes have worked together to build different kinds of infrastructure to support the implementation of ICWA. And as you would expect, in diverse state contexts, And with 574 federally recognized tribes that are incredibly diverse, these models for how to work together to produce better outcomes for kids and families by following the protections of ICWA look really different in different places. And so what's wonderful is that we can look at this natural experiment. We can look at this infrastructure that's been built by tribes and states across the country. And there are lots of good things that we can lift up from that. There are many things that additional jurisdictions can adopt or can adapt to make their own. So when we think about tribal-state relationships, there are lots of potential avenues for this to manifest. So we can think about things like state-tribal agreements. One of the things that ICWA explicitly does is to permit agreements between tribal and state governments. And these agreements can cover ICWA specifically. They can cover child welfare more broadly. Sometimes these agreements include funding. So the state may be passing funding through to tribes to support their role in helping the states comply with ICWA. So tribal state agreements is a big area of attention. I think there's a lot of opportunity there. Some states voluntarily collect data about ICWA cases or do ICWA case reviews. So that's a really positive model that we're seeing at some states, and something that the federal government could also consider in consultation with tribes, really working with tribal leaders to understand what is the data that tribes need and what's the best way to collect that and how should that be made available to tribes to ensure that ICWA is being followed. We have seen in the last legislative session a big increase in states that are passing state ICWA laws. So some of those were in place before the Brackeen case, but Erin was describing for us these claims about commandeering. And so a number of states just in this past term have passed new state ICWA laws. So that's another way of thinking about the federal requirements, but putting it in a local context. So state ICWA laws can be really important because they're the opportunity for states to think through how those federal protections would work within their state child welfare system. And so those laws can be really important. Some states are revising their state child welfare policy manuals with regard to how ICWA cases are addressed. Some states and tribes are having joint trainings of child welfare workers. And then there are great things that are happening on the court side too. So besides the child welfare agency side, on the court side, there are a number of states that have bench guides for ICWA. There are an increasing number of state ICWA courts that have a dedicated docket for ICWA cases, and that often have a much closer working relationship with tribes who have cases in those courts. So there's a lot of really wonderful things that are happening around the country. And this is a big opportunity to share more information about these models, to talk about what's really working. How are these things affecting the quality of the relationship between the state and tribe? How do they translate to different outcomes for kids and families? So there is a lot of work that's happening at the local level now, and some real bright spots and a big opportunity to spread more of that. And just briefly, I would just say, we're talking about tribal state relationships and mechanisms that can be helpful for implementation, given that the states are required to implement these protections, but tribes are a key player in this. And we talked a little bit earlier about building tribal capacity and sharing tribal best practices. And I would just say, tribes are such an important partner for states. States are often really constrained in their ability to adequately implement ICWA's protections if they don't have a good relationship with the tribe. The tribe has the best information about the child and family, about their extended family. They have the best information about services and supports, especially culturally based ones. And so tribes are just such a vital partner. And the stronger that tribal systems are, the better partner they can be to states. In fact, there's a 2005 study by the U.S. Government Accountability Office, GAO, that points out that tribes are critical partners to states in implementing ICWA. So although ICWA is governing state behavior, states really need tribes in order to do this well. And finally, I would just say, as we all know, not all states are eager partners to work with tribes in child welfare and across a whole variety of other issue areas. So there are some states where there's a pretty solid working relationship, some places where there are good relationships in child welfare, but that's not true always. And sometimes states are really reluctant partners to the table in this important work. And that's where I would highlight the role of the federal government, who can help to facilitate these relationships. Facilitate means to make easier, right? So the federal government can play a role in encouraging states to have these relationships, in incentivizing states to have these relationships, and in supporting good relationships between states and tribes. So I think there's a really strong role for the federal government to play here too.
Awesome. Thank you so much. We're actually going to jump to a question from our audience. This question comes from Matthew. What is the difference between tribal adult court and tribal family court involving enrolled tribal children? ICWA tribal member our ICWA tribal workers must be present or not present when a joint custody is involved. So we're getting a little into the weeds, and I think Aurene, I'd love to hear your perspective on that and a little bit of response to this question.
Sure. So tribal, adults who go through the court system is completely separate from children's cases that go through the court system, both in tribal court and in state court. In family court, everything is confidential. Children's information is very well protected. Social workers are involved. But when you have an involuntary placement or proceeding, that's different from a custody proceeding that might be between parents. And so if you have a joint custody proceeding, that's something that would not involve the Indian Child Welfare Act. The act only applies to involuntary placements. So there would not be an ICWA worker that would be likely present at a joint custody proceeding. But if it was an involuntary placement, then ICWA would apply and a worker would probably be present.
Thank you so much. We're going to move to, oh, yes, please.
I was just going to add one building off of that, just one other comment, just to clarify that ICWA also only applies to state court proceedings and doesn't apply to tribal courts. And so Congress could have, had the authority when it was writing ICWA to have it extend to tribal courts. But again, it was to remedy the widespread removal of Native children by state agencies and state courts. And so ICWA only applies to state court proceedings. Some tribes have adopted provisions of ICWA into their tribal codes, but in general, tribes do not have to follow ICWA in their tribal court proceedings.
Oh, thank you so much. Again, we're going to move to our very last question, knowing that our audience is mostly funders. When we talk about truly supporting ICWA and next steps, it is much more than writing a check. There are layers that go into this work and layers that go into making ICWA very effective. We'd love to hear from each of you about these efforts, about what they look like on the day-to-day that funders might not be aware of and are vital to creating a strong system, or programs or legislation that could be developed with the right support. So want to start off with, let's start with Dr. Joannie.
Thank you so much, Sister Brittany. So I think that when we look at some of the underlying historical implications, underpinnings of where federal Indian law and policy has led our communities to be today, it's critical to include in the dialogue that we will not go back to a place where our children are being taken from our communities, where our children are stolen. And really our work at the National Native American Boarding School Healing Coalition centers on the idea of truth, justice, and healing. And we are the leaders in bringing this work forward and In fact, looking at the future legislation that we're pushing through on the Senate side right now, Senate Bill 1723, sponsored by Senator Elizabeth Warren, is about establishing a commission on truth and healing. And so in order to move forward and look at how we can better support our communities for our future generations, we really have to understand the history of what has happened to our communities, and also looking at the ripple effects of our parents and our grandparents who may have not been respectfully in the best position to parent our children, or parent ourselves, and looking at how those are direct correlations to these different pieces of federal Indian law and policy. And in looking toward, the evaluating who's responsible in terms of the agencies historically who have been at the hands of not only executing, some of these programs and schools, it's important to understand also who holds these records. And so part of our work at the coalition is to gain access to those records so that we can continue to build our database and connect all these records so that folks who have been not only removed from community and or never made it home, their descendants, and as well as themselves as survivors, have an opportunity to make those connections through our database. So really, it's an understanding of the evolution of all these laws that are specific to Native children. What are some of those transitional turning points from where we saw military administered and government and church administered eradication to assimilation? So I feel like those are critical pieces to the dialogue. And if anybody wants to get more involved and learn more about our bill, again, it's Senate Bill 1723. And some of the key provisions of the bill are to examine the location of where our children are buried. And going back to what was mentioned earlier by Erin about who's coming to the table representing in these cases. You have Gibson Dunn, who was representing the Brackeens pro bono. And so if we look at the heart of this, it really comes down to economics in Indian country. And looking at, previous folks who they've represented, we know that there's major interests around energy transfer partners, Enbridge, Chevron, Amazon, Walmart, to name a few. And, thinking about the larger blueprint for trying to redirect and break up tribal sovereignty, there's all of these underlying pieces that also exist. And so that's why it's important to also share and get the word out about this bill being passed and looking at those ongoing impacts from boarding schools. And in fact, in 2019, November, in Tulalip, Washington, we actually held our last in-person event at in the Tulalip community, and it was a healing summit. And one of the things that forever will remain in my heart was our blanketing ceremony at the end of our summit. And we not only recognized survivors, and we also wanted to include those who have been through the foster system. And so if you can imagine this line of elders and you keep going down and down the line, and then you see children and youth who are also being blanketed, we know that, this is still ongoing. This is ongoing genocide. And that's why it's important to protect ICWA and to protect other organizations who are on the ground level doing this work. To learn more about us, please go to boardingschoolhealing.org. Thank you.
Thank you so much. I want to pass this question again to everyone. So, Aurene, what else do funders need to know? What do they need to be aware of, and how can they support?
Sure. So, I think one of the things Joannie was talking about, is the boarding the boarding school issues and how, that relates to ICWA, and, how that was, those are part of one and the same policy. But I think the Indian community as a whole, this is a very complex issue, and ICWA is one part of it, but another part is, our efforts to deal with the effects of colonization, not just in child placement, but in terms of healing our community and dealing with mental health issues, and healing from just the historical trauma that our communities have faced. And so tribes are really doing all of those things, not just trying to deal with placement as it is now, but also preventing placements in the future. And that takes a lot of time and a lot of effort. I think one of the things that if you're part of a community that if you have the time, if you have the ability, we're always in need of people to take children as a foster parent. We're always looking for families who have the time, the ability to love, to give to someone, even on a short-term basis while their families heal themselves. So if you have the time and the ability to do that, I would really urge that. If you're not a part of a community, or you want to just try to help out, there are also communities that are spread out across the country. Not all Indians live on reservations, and we have centers in different cities throughout the United States who provide help to Indian communities in those cities. And so if you're located in an area, or you need to help, you're interested in supporting one of those programs, I'm sure you can reach out to one of us and we can help connect you with those programs. And I think just the last thing that I would want to stress is that the National Indian Child Welfare Association is a great resource in providing training, not just to tribal communities, but also to state and local governments and their social workers. And I can't advocate enough for how much training affects outcomes when you're talking about people who don't deal with Indian children every day. And having that training and having the ability to provide that training and having NICWA be able to do that is a fantastic resource for Indian country. So I think if I were to make any recommendation, I would be to please look at what NICWA does and consider supporting them. Thank you.
Thank you so much, Aurene. Erin, the same question for you. Yeah. What would you like to share?
I agree with everything that the other panelists have said. Just in terms of what I might add, I would say that ICWA is an incredibly important law and needed, and I think everyone who is involved is committed to defending it for as long as we might need to. As I mentioned in my last comment, it is a law that faces state child welfare agencies and state courts, and I think from what we know, the outcomes are better for Indian children, as we've all said, when they're placed in their families and their cultures and communities. But to build on that, tribe, it's always worth reminding folks who might not work with tribes on a day-to-day basis that tribes are sovereign governments, and that they have their own child welfare programs and their own tribal justice systems, and that they also have inherent concurrent jurisdiction with states on children's issues, regardless of whether or not a tribe has tribal land or not. And so, ICWA is applying to those cases that are in state courts, but there are thousands of children who are in tribal child welfare programs and tribal justice systems, and that's where the outcomes are the best for children. And I say that just in using Alaska as an example. Alaska has 229 tribes. 228 of them do not have reservations. They are overwhelming. Those communities are overwhelmingly rural and not accessible by the road system. And the state of Alaska does not have a presence in those communities. And so if there is an issue where a family is struggling, it is the tribe who knows that before anyone else, and who is best positioned to potentially help that family and help that child. And so to the extent that funders can advocate or use their powers to help continue to build up tribal child welfare programs and tribal justice systems, I think that the goal that I've heard, my clients say is that, one day there might not be a need for ICWA because children won't be in state systems to begin with. They'll be in tribal systems where they are better served. And so I think anything that folks can do either in federal advocacy, making, federal funding streams more available so that they're not competitive grants where tribes are competing against each other for this type of money would be extremely helpful. And then, so NARF, we are involved in asserting the rights of tribes and Native organizations and Native individuals, and have been, as I mentioned at the beginning, in the ICWA space for a long time. So we are looking at, we're committed to this work, and we'll stay in these legal fights for as long as needed. And they've put our website up there. So thank you for that. And if anyone has any specific questions about NARF's work, don't hesitate to reach out. Thank you.
Thank you so much, Erin. And Sarah, we're coming to you for final thoughts. What would you like funders to know?
I think funders have so many resources at their disposal, certainly financial ones, but even above and beyond that, the power to convene people. A lot of the work that we're talking about is local systems change work. And this is work that needs to be guided by local folks, and especially guided by tribes. And so having tribal people on your board of trustees, having some kind of advisory committee or group, having Native staff are all really important steps to take. And I think just in conclusion, I would say, this work has generational consequences. It has generational consequences for kids and families and for their future children, generations down the line. And that opportunity for healing that Aurene was mentioning. And this also has generational consequences for tribal nations. And so this is important work, and it's important work to be doing now, especially while we have this momentum and solidarity. So now is the moment for action.
Thank you so much. And thank you everyone who tuned in, who've listened, who've learned, who were able to hear from these amazing leaders and the work that they're doing. And please don't let your support end here. We encourage all of you to donate directly to these organizations that you've learned about today. Each organization's website will be shared on the closing slides. And you can also learn more about how to get involved by reaching out to info@nativephilanthropy.org. You will also be receiving an email with a short link and a brief survey. If you will kindly take the time to share your thoughts, it only takes about 4 minutes, and it really helps us in doing these kinds of events. As a reminder, this session is open to the public as a highlight of our member benefits. NAP membership is open to our Indigenous relatives and non-Indigenous allies. If you're not a member of NAP and you would like to learn more, please visit nativephilanthropy.org, or you can email Rod Jacobs at rjacobs@nativephilanthropy.org. Thank you again for joining us, and we look forward to seeing you next month, where our membership education session will be on Indigenous data sovereignty. Hello, thank you.